Question: a stockholder claimed that his stock certificate was lost. After going through with the procedure for the issuance of lost certificate, and no contest was presented within 1 year from the last publication, the corporation issued a new certificate of stock in lieu of the supposed lost certificate. The stockholder immediately sold his shares and endorsed the replacement certificate to a buyer. It turned out that the original certificate was not lost, but sold and endorsed to another person. A. May the corporation be made liable by the aggrieved party? B. Who will have a better right over the shares, the endorsee of the original certificate or the endorsee of the replacement certificate? A. No. The corporation cannot be made liable. Except in cases of fraud, bad faith, or negligence on the part of the corporation and its officers, no action may be brought against any corporation which has issued certificates of stock in lieu of those lost, stolen, or destroyed pursuant to the procedure prescribed by law. B. The endorsee of the replacement certificate has a better right to the shares. After expiration of 1 year from the date of the last publication, and no contest has been presented to said corporation regarding said certificate, the right to make such contest has been barred and said corporation already cancelled in its books the certificate which have been lost, stolen, or destroyed and issued in lieu thereof new certificate. Question: Juan was a stockholder of Exco. He owned a total of 500 shares evidenced by cert of stock number 1001. He sold the shares to Pedro. After getting paid, Juan endorsed and delivered said certificate of stock number 1001 to Pedro. The following day, Juan went to the offices of the corporation and claimed that his certificate of stock number 1001 was lost and that, despite diligent efforts, the certificate could not be located. The formalities prescribed by law for the replacement of the lost certificate were complied with. Eventually Exco issued in substitution of the lost certificate, cert of stock number 2002. Juan forthwith transferred for valuable consideration the new certificate to Jose, who knew nothing of the previous sale to Pedro. In time, the corporation was confronted with the conflicting claims of Jose and Pedro. The board of Exco invited you to enlighten them on these questions, viz. A. If a suit were to be initiated in order to resolve the controversy between Pedro and Jose, should the matter be submitted to the SEC or to the regular courts? B. Between Jose and Pedro, whom should the corporation so recognize as the rightful stockholder? How would you respond to the above queries? 1997 Bar, A. The jurisdiction of the matter belongs to the regular courts. Under Section 5.2 of the SRC as amended, the jurisdiction for intracorporate controversies was transferred from the SEC to the regular courts. B. The corporation should recognize both Pedro and Jose as rightful stockholders if there is no overissuance of shares resulting from the two transactions without prejudice to the right of the corporation to claim against Juan for the value of the shares sold to Jose.